Good morning, everyone. Welcome to today's session. We are just waiting for a few more people to join, and then we'll kick off in just a few minutes. Thank you. Good morning, everyone. Welcome again to today's session. My name is Ian Kaita. I'm a partner in the projects practice at Anjawala & Kana. We thank you once again for joining us for this series of webinars focusing on project development and project finance and PPPs. In the last session, we introduced PPPs in the context of infrastructure development projects. We also introduced the concept of risk allocation in PPPs and project finance. And we also contrasted PPP procurement to traditional forms of procurement. We also looked at the various forms or models of PPP contracts. And lastly, we introduced project finance and contrasted it with traditional corporate finance. So today we want to introduce equity structuring in the context of PPPs or project finance transactions. And as we mentioned last time, is that the financing for a project will typically involve both debt and equity, debt from third-party lenders and equity from investors. So today we want to focus on the equity structuring piece of it. So what you see on your screen there is a model that highlights the typical structure that you have as far as equity is concerned. You will, in the initial stage, have a joint development agreement, which is essentially an agreement between parties who want to develop a project together to regulate their relationship and how they will go about developing the project. This will typically be in place before the detailed subscription and shareholders agreement has been developed and become effective. And so there'll also obviously be the debt piece from the external financiers. So our focus today is on the equity, and we will start by looking at the key equity documents, which is the development agreement, and then we'll also look at the shareholders agreements. So let us now turn to the joint development agreement. As I mentioned, the joint development agreement is an agreement between two or more parties who want to collaborate to develop a project and to regulate their investment in the project for a period of time, typically from the inception of the project until financial close, where the parties would have finalized their underlying equity documents. And then those would then become the documents that govern their relationship as equity parties in the project. And so the purpose of the Joint Development Agreement, or JDA for short, is to record the commercial agreements between the parties with respect to how they intend to collaborate in the development of the project and to regulate their relationship as interested parties during the project's development. And it also then lays a groundwork for the underlying equity agreements for the subscription and the shareholders agreement, which will then come into force at a later stage of the project. Then what are some of the key issues that parties would be concerned about while structuring their JDAs and recording what has been agreed in the JDA? Some of the preliminary considerations that parties need to flesh out are, for example, what are the objectives of the parties? What does each party bring to the table, if you will? Because, for instance, there will be those parties who are simply finance parties, but will not necessarily be involved in the actual development of the project. There will be those parties who are more involved operationally and will be the ones developing the project, and therefore they may have an equity or a financial contribution as well, or their contribution may be purely in the actual operation or development of the project at that early stage. Again, how much control should each of the parties, given their relative contributions, have during the project's development? Which decisions should be subject to approval by the other party? Which decisions can, particularly the party who is mainly the development party or responsible for the development, which type of decisions can that party make without needing the approval or consultation with the other party or parties? And what are the obligations of each party, both the developing party and perhaps the more passive finance party, with respect to the project development at that stage, and what protections are available to the other party if those obligations are not fulfilled. And then an important question to think about at that early stage is, what is the ultimate objective of the parties? Do they intend to develop the project and then sell their interest to a third party later, or exit from the project? Or do they intend to then own the project on a long-term basis and continue to operate the project after it has been developed and after financial close? And so to summarize, the key areas that are typically of concern are the funding, as we mentioned. What is each party bringing to the table? To the extent one or some of the parties are bringing sweat to the table rather than money, then how is that recognized? To the management and oversight of the project, who is responsible for what aspects of the project development, and which decisions require all parties to be consulted or to consent to certain decisions, which decisions can be taken by one party or some of the parties without necessarily consulting with the others. Another key aspect is exclusivity. You want to make sure that, for example, if you are then entering into an arrangement with a party who's a project developer and may have other interests in other projects, that those are disclosed. And ideally, you want to make sure that if, for example, some of those interests might be interests that conflict with the proposed investment in the current project, then you consider whether there should be some stipulations around what can or cannot be done by the parties with respect to other projects. So for example, if you're developing a project at a site where within proximity of that site, there's another project that could conflict, and not necessarily conflict in the sense that it's a competitor project, but also simply because, for instance, if say there's a wind farm that you're looking to develop, and then there's another proximate site not too far from there, and which may then have actual technical impact on the project you're seeking to develop, should you then have some restrictions around how proximate that competing project should be to the project you're looking to develop. And then around that also is things around who the other parties can bring to the table, be it from a concern around such matters as restricted parties or sanctioned parties and other commercial sensitivities that some of the parties may have. So it's important that those things are brought to the fore early and discussed and recorded appropriately in the joint development agreement, so that then at the point of equity subscription, you are not having debates or disputes around some of these issues. Then, of course, some of the other issues that will come to play is, for instance, under what circumstances can a party withdraw or exit from the JDA, and what should be the consequences of such exit. And part of that would also be forced exit in the context of a breach of obligations by one of the parties. And of course, projects of this nature tend to be complex, and despite the best interests of the parties, sometimes disputes are inevitable. And therefore, it's important for the parties to consider how disputes arising under the JDA are to be resolved. And what you sometimes see is that can involve two levels of dispute resolution. One that is internal to the joint venture, if you will, and that is, for example, parties setting up either a board or even a committee within that structure to try to resolve disputes in the first instance. And if that internal mechanism does not yield a resolution, then how do the parties then take the dispute to a third party for resolution, be that arbitration, be that the courts, be that a mediated process, or indeed, depending on the nature of the dispute, an expert determination. So again, fairly quickly, when it comes to matters of funding, what you want to set out very clearly is what each party brings to the table. And as we mentioned, where some of the contribution by one of the parties is not cash, but is in kind, then it's important that that is clearly recorded, and the terms of that in-kind contribution and what it actually means in terms of eventual equity down the line is well set out. Often you will find that one or some of the parties are the ones funding the development costs, and there'll typically be some sort of loan to the project company or another method by which the financing being provided by one of the parties to the JDA is recorded. And the terms of such financing are clearly specified, and how that party then may recover its the amount it has funded in the event of a default, or indeed how that financing then translates to future equity. In terms of management and oversight of the project, because at this stage, you're not necessarily shareholders in a company, this would be more in the nature of what we call contractual joint ventures. And therefore, typically, whereas in a corporate joint venture, you will have a board structure as your primary form of governance. At this stage, what you have then is some sort of management committee or project committee, as sometimes tends to be the phrase used, that then functions more or less like a board in the context of a corporate joint venture. And so when you're structuring your governance structures around the management committee or the project committee, some of the things you need to think about is how do we appoint representatives of the different parties to that committee? And how do we remove them, whether voluntarily or in the event of an issue with respect to that representative? What are the different roles of the different members of that management team or project committee? How do decisions get made? How are meetings structured for that project committee? And again, just going back to what we mentioned earlier, what decisions may require a higher level of consultation and which ones can then be made by that project committee without necessarily directly consulting the equity parties or eventual shareholders. So we've already discussed exclusivity. The other point I want to mention in a bit more detail is termination. As I mentioned, it's important to specify the circumstances in which one party may terminate the joint development agreement. And some of those would typically include things like if there's a change of control that has not been authorized. For instance, then one party may wish to exit, particularly because, as we mentioned earlier, if that change in control then results in another party to the joint development agreement being a party that other party simply cannot do business with, either for commercial reasons or indeed legal reasons such as sanctions, then you want to be able to exit at that stage. Other reasons could, for example, be the insolvency of the other party or its parent company, and then breach-related events. And in addition to grounds for termination, then it's always essential then to set out and clarify what should the consequences of that termination be. As we mentioned earlier, if, for instance, you're the party that has been funding development costs and there's a loan agreement relating to that development cost funding, then what should happen in that instance? Would that then translate to an acceleration of that loan? And how do you recover your money back? To the extent then there's already shares that have been granted in a project company, then should that termination then trigger a transfer, an obligation to transfer those shares by the defaulting party? We also mentioned dispute resolution and the kinds of escalations that you resolve a dispute internally first through some mechanism that you have set out, and then recourse to external mechanisms, be that mediation, be that an expert determination, or be that an outright arbitration or a court process. We will not go into the pros and cons of each of those. I believe many of you will be familiar with the arguments for or against each of those mechanisms, but we can certainly elaborate on that in future sessions. So that gives you in a nutshell an overview of what joint development agreements are intended to achieve. And as we say, they are a precursor to the main either share purchase or subscription and the shareholders agreements. And at this stage, we will then turn to share purchase and share subscription agreements, which are in principle the documents by which then the parties acquire their equity interests in the project SPV. So the distinction there being in that in a purchase, you're buying shares from an existing shareholder. In a subscription, you're not buying shares from an existing shareholder, but you're being allotted shares in the company by the company itself. But in terms of the key commercial provisions and key terms, they are broadly similar. And so we will now turn to looking at some of the key considerations that should be on top of your minds as you're structuring and negotiating your share purchase or subscription agreements. Some of the key considerations will be with respect to the conditions precedent, to the agreements becoming effective, and also to the completion of the equity investment. And those would range from commercial conditions precedent relating to, for example, development milestones with respect to the project and other commercial points. Some of those conditions precedent will also be regulatory in nature. For instance, antitrust or competition approvals that typically may be required to be obtained. Other conditions, regulatory conditions precedent would, for example, relate to key authorizations from regulators, such as in the case of energy projects, then you would typically require that your offtake agreements and other agreements are approved by the relevant energy regulator in your jurisdiction. And so those would typically form part of the conditions precedent to a party then subscribing to shares in the project SPV. And then some of the other conditions precedent you would typically see is around issues such as material adverse changes. Given how long it takes to develop a project, sometimes parties would want to make sure that although they've committed to an investment, that if there's a change in circumstances that is so material, and that may not necessarily be predicated on a breach by the other parties, but there's such a change of circumstances such that it forces the other party to reconsider the economic consequences of the investment, then those are things that ideally should be written into the documents so that parties are clear under what circumstances such rights can be exercised, and as far as possible to try and minimize disputes around those issues down the line. And obviously the other point is consideration, and that is simply price. At what price will the parties be subscribing for shares in the project company or in the holding company, which in turn will own the project company. And in addition to that, it will be questions even around where do we have our holding company located. Typically tends to be offshore, and it's important then to have that discussion early enough at the point of the JDA so that parties understand where, at what level they'll be investing, and then take advice, particularly with regard to the tax implications of that investment in an offshore company, and not just at the point of entry, but also at the point of any possible exit down the road, what different jurisdictions in terms of holding company jurisdictions may mean for an exit by that party. So again, as far as consideration is concerned, it's important, particularly for those parties for whom the contribution is in kind, either by way of sweat or other means. For example, a party that might be bringing to the table land for the project site, for instance. And it's important that then parties agree a mechanism by which that contribution is valued for purposes of recognition as part of that party's consideration for its shares in the project vehicle or in the project holding company. In addition to that, a lot of time is always spent with negotiating warranties and indemnities. And depending on which side of the equity parties you're representing, then it's important to understand what is the key driver, what are the key risks that the party concerned is trying to protect themselves against, and then that way then try and reach a sensible balance between protecting the incoming investors, but also acknowledging that there is certainly risk in investing in projects of this nature, some of which must be shared by all the parties investing, and therefore it cannot be foolproof, or indeed it cannot be that 100% of the risk is borne by one party. So then with that understanding, there's always a balance to be struck, and also taking into account the fact that the incoming parties would have, in any case, had an opportunity to carry out substantive due diligence on the project and on the various vehicles through which the project is being operated. And therefore, some level of comfort should also be derived from the due diligence. And then that should also inform the extent to which warranties and indemnities would be negotiated. The other issue to highlight and describe properly in the subscription or share purchase agreements is the actual completion mechanics. At what point can completion be triggered? Typically after all the conditions precedent have been satisfied or indeed waived, and you will need to be clear as to who has power to waive which condition and in which circumstances those conditions can be waived and which ones cannot be waived. For instance, regulatory conditions typically cannot be waived. And then to figure out whether there might be even room in the interest of progressing the investment, there might even be room to have some of what were previously conditions precedent being matters that can be dealt with after the investment by way of conditions subsequent. But in all these things, clarity is key. Again, as we mentioned earlier, partly in the context of warranties and indemnities, the party who is giving these warranties and indemnities will typically want to limit its liability, again, taking into account the fact that the other parties have had the opportunity to run their diligence, and taking into account the fact that there may be matters which it would not be reasonable to expect one of the parties to bear 100% of the risk. So you will typically find that as part of that balancing act between the extent of the warranties and the extent of the indemnity cover, then part of the pushback that the party giving these warranties and indemnities will typically involve some level of limitations of liability. And those would be either in terms of specific exclusions from the scope of indemnity coverage, for instance, limiting the financial extent of that liability, limiting the time within which claims can be made, requiring, for instance, the other parties to have recourse to any available insurance before pursuing a claim, and all manner of other things that would typically be negotiated and written into the subscription agreements as a method of trying to balance those risks and expectations of the parties. So assuming all goes well, and the CPs have been satisfied or waived, and the parties have obtained all the regulatory approvals that they needed, and have then closed on the equity subscription or the share purchase, then the next document that comes to life at that stage is the Shareholders Agreement. So this then is a document that regulates the relationship of the parties now in their capacity as shareholders in either in the project company or in the project holding company. Whereas before they were purely contractual joint venturers, now they are shareholders in a company. And so the Shareholders Agreement is a document that records that relationship and governs it. Now, of course, in many jurisdictions, the legal document that governs the relationship between shareholders in a company is the Articles of Association. Typically, that is a public document that would be recorded in the company's registry in that jurisdiction. But there will be a lot of issues and matters that parties want to regulate that go beyond the basic legal relationship between those parties in their capacity as shareholders in the agreement. Some of those issues will be issues that are of a sensitive commercial nature and confidential. And therefore, the idea is that although you could simply rely on the articles will not typically include some of these more commercially sensitive matters. It will lay out the basic legal relationships between the parties, and also bearing in mind that that is a public document. For purposes of sensitivity, these are the matters that are not necessarily, that are important commercial issues, but not necessarily going to the heart of the basic legal relationship between the parties, can then be dealt with by way of a shareholders agreement that typically is a confidential document that does not need to be recorded in any public register, but at least as far as the relationship between the shareholders themselves can then flesh out that relationship in a more exhaustive manner than the public document would do. And so the shareholders agreement, or the SHA for short, defines the relationship between the different shareholders. It also highlights the extent of each party's shareholding in the undertaking, and then goes on to describe and outline how the business is to be managed, and then other issues to do with the rights of each shareholder, matters to do with exit, both voluntary and involuntary exits, and matters to do with any additional obligations that the parties have, for example, with respect to future financing of the business. And so we'll now turn to just highlighting some of the key clauses that would typically be found in a shareholders agreement, and which then tend to be the focus of a lot of the negotiation around these documents. One of the key areas is to do with the management and control of the company. As we mentioned earlier, at the JDA stage, you don't have a board structure. You simply set up a project committee or management committee to govern the company. At this stage, when you are now shareholders in a company, then the board tends to be the main vehicle by which the company is managed and governed. And therefore, questions of representation on the board, questions of veto right or reserved matters then become important at that stage. And with respect to board seats, typically the default rule tends to be that board seats then are allotted on the basis of the shareholding strength of the various parties. But that's not a rule of law, that is just a rule of good practice. And therefore, nothing stops the parties from arranging their board seat allocation in a different way. And it may be that for a variety of reasons, for example, where you have a party who may have substantial contribution to the project by way of sweat or other in-kind contribution, but not necessarily by way of a financial subscription, being given a fairly high level of say beyond what perhaps their financial contribution suggests. So allocation of board seats is an important matter. Two is, as we said, reserved matters. What are those decisions that can be undertaken by the board without either resorting to the shareholders, or indeed even within the board itself? Are there decisions for which there must be unanimity or an elevated level of affirmation of that decision by the board members, or is a simple majority of the board affirming that decision sufficient? Now, typically the decisions that will be subject of reserved matters will be those decisions that have a substantial impact on the company and its future. decisions to do with such matters as either admission of a new shareholder or decisions to do with, say, a material change in the nature of the business, or even matters to do with a material investment beyond a particular financial threshold, or indeed even a material piece of litigation that the company might be considering. So there's a whole host of issues that could then be the subject of reserved matters, which require either unanimity or an elevated level of approval by the members of the board. The other key area of discussion and negotiation is around financing. And some of the questions that typically then come in is, for instance, to what extent should the company maintain reserves for different purposes, or should all of the net profits of the company be distributed to the shareholders? How would those reserves be deployed, or to what purposes can those reserves be deployed? Two is, to what extent can the company resort to external funding, be it from banks and other development finance institutions, or is there an obligation then for the shareholders to continue to fund the business? And what does that mean, for example, in terms of those shareholders who, for one reason or another, are unable or unwilling to provide further financing? And in connection with that, particularly in the context of external financing, should the shareholders, for instance, be obligated to provide any security or guarantees to support the borrowings of the project company? And if so, on what terms? To the extent one of the shareholders is willing to finance the company by way of a shareholder debt, on what terms should that debt be made available to the company? And what priorities, if any, does that debt enjoy relative to other forms of external financing that the company may have access to? And of course, additional equity, to the extent the parties would want to finance by way of additional equity, then on what terms, and what should happen to those parties that for a variety of reasons may either be unwilling or unable to take up additional shares? Should they be diluted or not? The other key area that typically tends to form an important part of the negotiation in the shareholders agreement is around the transfer of shares. It's important in this agreement to have a clear mechanism for the transfers of shares, both from how the transfer is in fact administered by way of how is a notice for an intended transfer of shares to be given. Do we allow a party to transfer some shares, or is it an all or nothing proposition? How do we establish the price or a fair market value for the shares in the company? What time do we give to the other shareholders to confirm if they want to exercise any preemption rights before the intended transferor or seller can then go out to the market to try and sell those shares? And so it's typical to have some form of preemptive rights in favor of the existing shareholders. Those, in a nutshell, being rights such that the existing shareholders have the first right to acquire shares from any other shareholder who wishes to sell. And so that shareholder is required to offer those shares to the existing shareholders before it can offer them to the market. There may be some level of flexibility around preemption. So, for example, where a party is simply transferring shares internally within its group for purposes of, say, some group restructuring. So there's no external party that is being brought into the existing relationship, but it's simply an intra-group transfer. So in those cases, you might find what are typically described as permitted transfers, under which a party could then transfer to an affiliate. The understanding being that those transfers do not result either in a change of ultimate shareholding of the group because it's within the same group, or the introduction of a new shareholder to the relationship. And therefore, in theory at least, the other parties will be more relaxed about this than they are perhaps about a transfer to a third party. There will be instances where parties, in addition to expressly stating what are permitted transfers, will want to expressly specify the types of transfers that are prohibited. The more obvious ones are, for instance, transfers to a sanctioned person, or indeed someone whose either business practices are such that the other parties may have sensitivities with having those persons as core shareholders in the project vehicle. And that could range from anything now. We are seeing beyond the traditional sanctions provisions, we are seeing parties also sometimes specifying details around certain parties that for a variety of commercial reasons beyond sanctions they will not want to do business with, such as certain competitors, or we've also seen parties recording things to do with, for example, groups that have been the subject of any debarment from public prosecution, from public procurement. So the commercial concerns around restricted transfers can sometimes go well beyond sanctions, which perhaps is what people are more familiar with. But of course, when you start imposing these kinds of restrictions, and depending on how they are worded, it's important to bear in mind that this could also have other knock-on consequences, not just on, you know, the marketability and of the shares. It's important that you don't restrict the ability to exit so far that you essentially take away any market for those shares and make them illiquid. But other knock-on effects could, for example, be that those kinds of restrictions could also then have an antitrust impact. So it's important to carefully consider how far you go in terms of writing in restrictions, particularly where they relate purely to matters to do with competitors rather than issues such as sanctions. The other instance of transfer is involuntary transfers. And this is where, or compulsory transfers. And this is where events have occurred or circumstances have occurred that would then force the party affected by those circumstances to sell its shares or be required to sell its shares. And those could range from bankruptcy or insolvency related events, change of control of a shareholder, again, just tying back to the question of restricted transfers. If a party has suffered, whether voluntarily or otherwise, a change of control, either directly or indeed indirectly at its parent company level, that results in an undesired party becoming a shareholder or indirect shareholder in the project vehicle, then the other parties may require that then is a trigger for a forced sale. Other forced sale events could typically be around a breach of key obligations under the SHA and under any other project agreements which that particular shareholder may be involved in. If, for example, a developer shareholder is also involved in, say, the EPC contract for the project or the O&M project, you may find, for example, that a default by that party or its affiliate and a material default under that EPC or O&M or other project agreement, then in turn triggers a default under the project shareholders agreement with the consequence of a forced transfer. Related to this question of transfers is that, again, in the interest of ensuring that the remaining parties have a clear sense of who is potentially coming into the relationship as a new shareholder, it's quite common to have what is known as a deed of adherence being a requirement as part of any transfer mechanism for shares in the project vehicle. What the deed of adherence in simple terms does is an acknowledgement and affirmation by the incoming shareholder that they accept to be bound by the terms of the shareholders agreement upon their entry into the project company as shareholder, as though they were original parties to the shareholders agreement. So that then you're not in a scenario where some of the shareholders are bound by the shareholders agreement, but an incoming shareholder is not bound by the shareholders agreement. So again, a deed of adherence is a common tool that parties will see and insist upon being executed by the incoming shareholder in order to bind them to the shareholders agreement. So again, reserved matters, we discussed this at some length when speaking about board-related issues. Similar concepts will apply as far as shareholder decisions are concerned. And therefore, the key thing is to ensure that you're clear as to which matters require an elevated or unanimous level of affirmation by the shareholders. But at the same time, be very careful, again, depending on which side of the table you sit, be very careful not to create unnecessary deadlocks by way of having, say, unanimity on every last decision, which can, even with the best of intents, lead to a deadlock or can be misused by another party for mischievous reasons to create an unnecessary deadlock. But again, because typically what would be shareholder reserve matters are matters that are material and important to the business, it is important to think about what should happen if we cannot agree on these reserved matters, because essentially then that could result in a deadlock. And therefore, sometimes it's important to then write in the actual consequences of a failure to agree on a reserved matter that then triggers a deadlock. How do we resolve this deadlock? And these ones tend to be a bit more complicated because, unlike other issues or other disputes that would typically arise that are more legal in nature, the challenge with most deadlock scenarios is that this is not a legal dispute per se. This is a matter where parties simply cannot agree on an important commercial issue. And so it's not simply a matter of saying that let us resort to dispute resolution, because, for instance, on that commercial issue, an arbitration will not necessarily resolve it for you because it's not a legal dispute here. It's a dispute on a key commercial issue. That's not a legal issue per se. So then what kind of deadlock resolution mechanisms you put in is an important consideration, and can often form a fairly exhaustive part of the shareholders agreement. Then in terms of exit mechanisms, as we mentioned, different parties will have come into the investment with a view, with different expectations as to how long they intend to stay in the project and at what stage they wish to exit and on what terms they wish to exit. Classic example being, for instance, investment funds who will have typically a defined shelf life by which they must have exited or attempted to exit an investment and returned money to their LPs or to their investors. And so therefore, for these types of vehicles, they will have a relatively rigid approach to exits and will need to have well-elaborated exit mechanisms available to them. unlike, say, what one would call a strategic or perhaps longer term capital provider who may well be willing to stay the course for a long time because they don't have the same pressures as an investment fund to return capital to shareholders within a defined lifetime of the fund. So again, all those things then, depending on who you're representing, become important considerations as to what you negotiate and what you write into the shareholders agreement. Because then if you're representing a fund, for example, you want to be careful around that ability to exit, the timetable around that exit, and what happens if, for whatever reason, you cannot get a market for your shares out externally. Should you then be in a position as that shareholder to put your shares to your fellow shareholders and essentially force them to buy you out, or what happens? And then again, depending on the strength of your shareholding, you may also want to have the ability to force the other shareholders or require them to sell at the same time that you're exiting. And that is essentially the concept of a drag or a drag along right, as it's typically known. The idea there being that in the instance where the person who may be interested in your shares wants a controlling stake, you may want to ensure that you can then require the other shareholders with smaller stakes in the company to sell their shares alongside your stake, so that the incoming buyer can then acquire a greater level of control. And the inverse is also true, in that sometimes you may be a shareholder who has not a controlling stake, but does not want to be in a position where, because your minimal stake does not command much in the way of voting rights or control rights in the company, you do not want to be in a position where, if an incoming shareholder comes in that you're not even commercially comfortable with, you are then forced to stay on in that arrangement. So one of the things you could negotiate as that shareholder is the ability to require that those larger shareholders, at the point that they're exiting, are then forced to bring you to the table and to give you that same exit opportunity on the same terms, and to require that proposed buyer to also buy out your shares on similar terms. And that's what is known as a tag-along right. So some other provisions, deadlock we've discussed, so I'll not go over that again. Safe to reiterate that it's important that you consider deadlock resolution, and also bear in mind that deadlock is not necessarily a legal dispute, and therefore the mechanisms you write in relating to deadlocks would not necessarily be simply resorting to the dispute resolution mechanisms under the contract. You may need bespoke arrangements relating to breaking the deadlock. Confidentiality, and again, goes without saying that there'll be a lot in a shareholders agreement that is commercially sensitive to the different parties, and therefore it's important that you write in elaborate provisions with respect to confidentiality, but at the same time recognize that various third parties with particular interest in the project, so for example, other potential investors in the project, or indeed the lenders as far as the debt financing is concerned, various underwriters from an insurance perspective, or even in terms of credit enhancement structures, we want to review these agreements and understand them from the point of view of their, bankability and other considerations. Therefore, it's important that whilst you want to preserve the parties' confidentiality, that you allow some reasonable level of permitted disclosures to these kinds of interested parties, because typically it's for good reason that that disclosure is being required. Then, of course, dispute resolution. And again, there's no one size fits all. Different pros and cons to the different mechanisms for dispute resolution. But some of the things that parties should bear in mind is, for example, the nature of the dispute and what type of dispute resolution it lends itself to. If it's purely a dispute on a technical matter, for example, just a computational dispute, for instance, say on reimbursement of development costs as an example. So the only dispute is really about whether these costs are legitimate and the quantum of those costs. Those are the kind of disputes that perhaps don't necessarily need to go to court or arbitration, but perhaps can be subjected to an expert determination or an audit of those costs. Then other disputes that are more legal in nature could, for instance, be subject to either mediation or an arbitration or a court mechanism. Deadlock, as we've mentioned earlier, needs to be carefully thought through because it may not necessarily be a legal dispute. And given the consequences of a deadlock, you may need a whole bespoke mechanism as to breaking or resolving deadlock. Lastly, is also points to do with the ability to enforce whatever the eventual decision of the dispute resolution mechanism is, particularly with respect to court decisions. Because again, depending on the jurisdiction and depending on the on where your project vehicle is located, then you would need to ask yourself, for example, in that jurisdiction to which we are submitting disputes or to whose courts we are submitting disputes, can we enforce that court judgment in another jurisdiction easily? Is there a recognition of judgments treaty between the two countries, for example? Or indeed, even in arbitration, is the state in which we may need to enforce that foreign arbitral award a state that is a signatory to what is known as a New York Convention, or is it not? And if that's the case, then how easy will it be to enforce its arbitral award? And then by extension, to the extent there are other relevant project agreements relating to the equity relationships, then sometimes it's important to also harmonize the dispute resolution provisions with those that are available and the shareholders agreement, just so that if for example, there's a dispute under the shareholders agreement that in turn is closely related to a dispute under another project agreement, then you're not having two disparate dispute resolution mechanisms for what is essentially the same dispute. So again, it's important to consider what we lawyers call joinder provisions that then allow for that ability to harmonize dispute resolution provisions across a suite of related documents. And then of course, sometimes it's worth considering who your counterparties are, and also considering, for example, some of the limitations you may have. So for example, in certain jurisdictions in the region, you may find that in your PPP project, there's a requirement to have a state party as one of your shareholders in the project. And if you do then have such state party, and there's considerations around, for example, how do we enforce against a state party if that's a party we need to enforce against? Are there restrictions under that jurisdiction's laws that require that then we must submit, for example, to the law of that jurisdiction or to dispute resolution in that jurisdiction? And what does that mean practically for you? So lastly, of course, is warranties and indemnities and representations, which we, in the interest of time, we will not go into, given that we've already highlighted those when we were speaking about the share subscription agreements, and also mentioned the need to balance the scope of the warranties and representations, as well as a sensible approach to limitations, as well as also exploring other means that may be available for shifting these risks, for example, to insurance to the extent available, or also taking recognition of the fact that some of the concerns that would typically be sought to be addressed through warranties and representations could also then be pushed back against by way of allowing for exhaustive due diligence and also allowing for an exhaustive disclosure exercise to qualify those warranties. So I think in the interest of time, we will stop here for now and invite any comments that or questions you may have as we seek to wind up this session. And I believe that perhaps the best way to address questions would be in the chat box on the platform, and then we can pick them up on this end and try to address them for you. So one of the questions we see here is, how can project developers protect themselves in a shareholders agreement or JDA, given that most equity investors or lenders provide funding with greater asks? I believe the question there is that, given the fact that as a project sponsor, perhaps you may have the project opportunity, the people who are looking to provide you with financing will typically be, for instance, equity funds or infrastructure funds who typically have more financial muscle than you have. Then how do you protect yourself? I guess the answer there will depend on what the asks are, but I guess one of it is, for example, if it's in terms of decision-making controls, then you as the founders or sponsors of the project will still want to have, and the prime movers of the project will still want to make sure that there are certain decisions that cannot be taken by the financial parties without your affirmation and without consulting with you. One. Two is to have some level of participation and decision-making in either the project committee or the management committee at JDA level, and indeed in the board of directors when it comes to the shareholders agreement, once the company is now properly constituted in terms of equity. So at that stage, then you will want to make sure that you have representation on the board, effective representation on the board. And the other point then is, of course, the reserved matters. Again, both at JDA level and at shareholders agreement level, what are the reserved matters which you as, let's call it the minority shareholder in that instance, what level of minority protection do you have, such that key decisions that go to the heart of the investment or the business cannot be undertaken without your affirmation. And of course, then that also then boils down to what we were discussing around deadlock, in that how do we deal with deadlocks if we simply cannot agree on an issue that goes to the heart of the business. Then there's a question here with regard to completion mechanisms. I think the point there is that, as we say, the JDA is intended to deal with that time in the project life cycle where you do not yet have shares in the project company, or it hasn't been properly constituted, but there's a lot of development work happening with respect to the project. So essentially what you're trying to do is to lay out the roadmap to say, what is happening in terms of the development, and two, what is our eventual equity structure and how will we get there? And so some of the things you want to clarify is, for example, at the JDA stages, for example, what will be the relative contributions of each party and what will those mean in the eventual shareholders agreement? And once you clarify that, then you typically will not then flesh out the detailed completion mechanism in the JDA, but you will do so, say, in the actual share transfer agreement or in the share subscription agreement, because then you will flesh out the details around the sorts of regulatory approvals that you need, the sorts of commercial conditions precedent to be fulfilled before then the shares are allotted. So the usual right place to deal with this is in either the share subscription agreement or the share purchase agreement. But certainly in the JDA, then you can, at a very high level, lay out that roadmap. Then the second question there is, are there any special considerations for joint development agreements, shareholders agreements, or share purchase agreements used in energy projects? Well, again, no one size fits all. Every project will be unique and will have its own particular considerations. And some of these may well be regulatory. So for example, depending on the jurisdiction and how the particular project has been procured, you may well find, for instance, a requirement to have a government stake. So for example, if you then have a government stake because either a state party or a state off-taker is required by law or indeed practice in that jurisdiction to have a stake in the project company or in the project holding company, then you have no choice. You do have then to provide for that government shareholder, and then that then comes with its own challenges with respect to the fact that typically you cannot exit that shareholder involuntarily. You cannot dilute that shareholder, and you cannot get around that regulatory or just practical requirement to have a government shareholder. That's one of the things. So then when you have such a shareholder, then there's a whole lot of structuring that you will have to think about with respect to that shareholder, and then what level of powers do they have, and what level, particularly if that then will have conflicts of interest with respect to things such as your offtake agreements. So that is one area where then special consideration needs to be given to the nature of your shareholder, particularly if it's a shareholder that is essentially forced upon you by regulation. Then the next item there would be how well you draw your linkage between your equity investment and the actual effectiveness of the underlying project agreements. So for example, you want to make sure that as part of your conditions precedent, you are not being forced to invest as a private party in a project where all the underlying offtake agreements and energy regulatory authorizations have not yet been achieved. So that's one other thing that you want to make sure that in terms of alignment of timing and conditions precedent, then you're quite clear around those kind of mechanisms. And again, some of the other things that you'll see will then be very specific to projects. So for example, if you've developed a project and for a variety of reasons, the expectation in terms of output of that project at the beginning are not realized at the end, then the question should be, do you then build in particular milestones or mechanisms to deal with both issues to do with, for example, the actual output of the eventual project that gets developed, and two issues to do with, for example, in a highly regulated sector, if for whatever reason the kind of tariff that you had anticipated is for one reason or another varied, because these would often be outside the control of the project developers. So what controls do you have if that happens? Because of course, if there's any such variations to the project, then or the underlying tariffs, then they certainly affect the IRR of the investor. And so the investor will typically want to be able to have the opportunity to rethink its investment if those kinds of things happen. So those are just some examples. More will frankly depend on the kind of project. Is it a greenfield project? Is it a brownfield? And what are the particular risk issues or bankability issues around that particular project then that need to be thought through? And some of them may even be matters to do with land and other key ESG considerations that parties may have. So it really depends at the end of the day on the actual imperatives of the particular project. Then one of the other questions that's coming through is whether there are any remedies for, say, small developers or minority investors who may be subjected to drag-along rights in the context of a shareholders agreement, and particularly around the price or the offer that is being presented. Now, as you mentioned, the idea behind the drag is to give the party, particularly the private capital fund that is looking to invest in the project or similar investors, an ability to exit and an ability to actually convey to the new shareholder a controlling stake if that is what the new shareholder would want. And therefore they insist on a mechanism by which they can drag along the other shareholders in order to convey a controlling stake or a much larger stake than they themselves hold in the project company. So if you are the minority investor who is then on the receiving end of a drag right, and you cannot otherwise negotiate your way out of the drag right, then I guess the question partly around pricing is then, how do I make sure that if in principle I must be dragged, then I am being dragged at the same price or certainly at a fair price. And part of that then involves requiring that in the drag mechanisms, one is that then the price should typically be a price that is reflective of the fair market value of those shares. And to the extent the parties cannot agree on what is a fair market value of those shares, then you may want to insist that the price of the shares in the company is subjected to a fair market valuation by an external party. That's one. The other thing is that you may also want to have some stipulations around the fact that there should not be a discount being applied to fair market value just by reason that you are a minority shareholder. Of course, there may be instances where someone or the other parties may say that they may want to discount fair market value for the smaller shareholders to reflect the fact that they are not controlling shares. But in that instance, I think it's reasonable to insist that there should not be a discount by reason of not being a controlling shareholder. And a variety of other things you can do now simply around, again, the mechanism itself and the administration of the mechanism, clarity around who the proposed buyer is, timing, the timing of the process. And again, the key, as I said, is just making sure that the prices can be verified by a third party and that you're not being discounted. I think those are the key ones. Then there's a question here, when a condition precedent is not closed before completion and it's then made a condition subsequent, what mechanisms exist to ensure completion before it becomes a dispute and potentially a termination condition. So a couple of things there. One is that you want to be careful which provisions you allow to become conditions subsequent. It certainly cannot be regulatory conditions which must be satisfied before you complete, for example, monopolies or any other regulatory condition. So it would typically be non-regulatory conditions, but still important commercial conditions precedent. So to the extent then you have taken a view that these can be conditions subsequent, then in order to ensure that these are then achieved, it's a question of how you provide for them in the relevant document, if it's, say, the subscription agreement or share transfer agreement, or indeed if then this gets translated into an obligation in the shareholders agreement. So it's a question of first being very clear what that condition subsequent is, who is responsible for fulfilling it, providing for the timeline by which it must be satisfied, and then building in the mechanism for what happens. Will it then trigger a forced sale on the part of the party that has failed to fulfill that condition? And if so, will that forced sale be at a discount to fair market value, or will it be at fair market value? And if you're the person who's on the receiving end of this condition subsequent, you need to ask yourself very carefully, is this condition subsequent something that is within my control and therefore I'm relatively comfortable that I can achieve this? Or is this a condition subsequent that also has various externalities to it, being matters beyond my control? And therefore, do I want to be clear that if, despite my reasonable efforts, I'm not able to satisfy this condition precedent for reasons outside my control, should I then be punished by, for example, a forced sale, and indeed a forced sale at a discount for matters outside my control? And once you're clear on those things, then it's easy then to have that balancing act in the negotiation that then yields a balanced provision that, for example, may allow for circumstances where the failure to satisfy this condition subsequent is not really a default, and therefore should not trigger a discounted sale if it must trigger a sale in the first place, or indeed what other remedies exist to the other parties. So I think the key thing is understanding the commercial imperatives underlying that condition subsequent, understanding whether the level to which it's within the control of the party or is subject to other externalities, and on that basis then try and negotiate a sensible balance with regard to the obligation itself, and more particularly the consequences of not fulfilling the obligations, and then making sure that all that clarity, including all the administration around who makes that determination and what are the consequences of failure to satisfy the condition subsequent, are well and clearly written into the agreement. I do not believe we have any other questions at this stage, but if you still have any other points that you'd want to have us clarify, we are more than happy to do so. Please get in touch with us and we'll be more than happy to discuss those. Then just to lay out what we expect over the next sessions, given we are soon into the holiday season, we expect that we will be looking at some sessions perhaps early in the new year. And the next sessions we have in mind are, one, to now think about the EPC contracts and the O&M contracts. So our next session will be on negotiating and drafting EPC and O&M agreements. We will also now, after that, focus on the finance documents, both the primary finance documents and all the credit enhancement and government support measures that go with them from a bankability perspective. And we'll also, in a subsequent session, look at issues to do with tax structuring for infrastructure projects and land considerations in the context of these kinds of projects. So with that, ladies and gentlemen, I wish to thank you for your time. I wish to thank you for your insightful questions and for your continued support to our teams and the opportunity to continue working with you as you develop your projects. We look forward to opportunities to meet again in future sessions. And we hope that as things improve on the public health side, we can have these sessions in person in the future. So thank you very much and have a good day. Thank you.